Hi, everyone. Thank you so much for joining us today. I'm Marche, the webinar director here at Advice Chaser. Before we introduce our guest and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you this educational presentation today. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenter will answer those queries after today's webinar presentation. We do have a question and answer period at the end of the presentation. If you ask a question in the chat box and we're not able to get to it, go ahead and leave your contact info as well. We'll be happy to reach out to you after today's event to address that question. Once again, please don't hesitate to ask for clarification or expansion of the material. That is what we're here for, and we're excited that you're here. Well, I'd love to introduce you to today's presenter. Ransom H. Adams is a partner and wealth manager at U.S. Capital Wealth Advisors, and also earned a bachelor's degree in financial planning from Texas Tech University. He holds the designation of Certified Financial Planning Professional and has over 15 years experience in the financial planning world. Outside of work, Ransom is a husband, father, and an Eagle Scout. Ransom is based in Austin, Texas, but serves clients throughout the U.S. And I'm going to go ahead and turn the time over to you, Ransom, and I'm excited to have to learn what you have to say today. I'll go ahead and stop my share.
Perfect, thank you. Well, hello everyone. Thank you for joining us today. Got lots of great information to go over. I'm just going to catch up here on the slides. So today's presentation is about estate planning, and this is not just Texas specific. It's general concepts and planning rules that everyone needs to know and kind of be aware of. I'm going to start with some complexity, right? And then we'll simplify things as we go. This is a quick guide to estate planning. And so level one, right, kind of the beginning basics, we need to have a will. You may or may not need a living trust. Health power of attorney is extremely important, financial power of attorney. And then visiting the ownership provisions of accounts, right? You can own an account jointly, tenants in common. There are all kinds of different ways to own accounts. And then always review your beneficiary designations as well. That's keenly important. Level two kind of gets into some spousal gifting, some grantor retained annuity trust, which we'll talk about more in detail as we go. Also really just exploring, charitable donations, donor advised funds. If you're philanthropic and you like to donate, there's a great way to do that where you benefit the organization, but also benefit yourself from a tax perspective. An irrevocable life insurance trust is a very unique planning tool that we've done several of over the last few years. Interfamily loans are a great way to pass on, income and legacy to families as well. And then a special needs trust just addresses those with special needs to make sure that they don't get disqualified from any federal help or state help that they may be entitled to, but also ways to enhance and make their lives a little easier. Level three is really like domestic offshore trust, self-canceling notes. A self-canceling note is when you loan somebody money, they make you payments, but if you pass away during that period, the note is canceled and foregone, and that person no longer owes your estate or anybody else any money. And family limited partnerships and LLCs are a great way to transfer assets and be in business with family and do it in a very simple way that benefits everyone. There's a portability rule in effect now. It's one of the things that's always on the chopping block to be eliminated, but it's in effect for now. until legislation changes. But portability just allows you to use your spouse's estate tax deduction combined together with your estate tax deduction. And we'll get into more detail about that as we go. So this kind of shocked me when I was doing the research and looking at the slides. 59% of all Americans don't have a will, which is really strange. And in the state of Texas, if you don't decide who gets all your stuff when you pass away, a probate judge will decide for you. And you know, I don't want them saying how my stuff goes or who it goes to. I would rather say that while I'm alive. But with a will, your property is distributed in accordance to the language in the will. Without a will, your assets, like I said, may not go to the people that you want to have them. And family members also need to have access to your will and know where it's at. They don't necessarily need to know what's in it. They just need to know where it is in case something tragic happens. Again, just kind of reiterating some things. The will is very important. It helps direct who gets your stuff, how they get it, and what they actually get. A will appoints an executor or an executrix for your probate estate. They will file a motion with the probate court. They will be issued letters of testamentary, which then allows that person to act on behalf of the state, pay bills, take care of things that are existing after you pass. That person will do all of that. It also names who's to raise minor children in the event of a parent passing away or both parents passing away. Most times, whichever family member is most financially capable of finish raising the children will be appointed custody. And in my case, right, I've got an uncle that's a great guy, but he has no business raising my two boys if something happens to me. So he is not appointed guardian in my estate documents. So just be aware of that. Somebody might wind up raising your kids that you don't want to raise them. So let's continue. Some will substitutes that act in place of a will are certain types of ownership. So I can own an account with a TOD designation, which is a transfer on death, so that when I'm gone, it automatically goes to the person that's listed on the account. There's no probate, there's no hoops to jump through. You provide a death certificate, and then that institution, bank, investment firm, or what have you, will then transfer all those assets to you. POD, payable on death, is for bank accounts. TOD is for investment accounts. Beneficiary designations, again, are super important. IRAs, life insurance, annuities, things of that nature all have designated beneficiaries, which have nothing to do with your will. The beneficiary designation actually trumps a will and takes place of that. So even if I name one of my kids my beneficiary, and then in my will I say something different, the beneficiary wins in that all the time. And a living trust is also a good substitute for a will as well. So this is kind of a discussion on how assets pass once you pass. So you can hold accounts jointly, and that means that each of you are equal owners. And that's a good way to do some basic estate planning. If something happens to me, the joint account that I own with my wife then becomes hers solely. Tenants by the entirety is another designation that kind of splits things into percentages, which is a nice way, applicable way if that shoe fits, to do things as well. Again, beneficiary designations, all retirement accounts, 403Bs, 401Ks, IRAs, annuities, life insurance, they all transfer via the beneficiary designation. Things held in trust don't necessarily go through probate, but the assets need to be titled into the name of the trust or owned by the trust in order to avoid probate. So individually owned assets, if I own something on my own, just my name on it, that is something that will go through probate. It's a great review for people to understand how things are titled, how things are going to pass, and then making those changes in accordance to that. This is important too, just how marital and non-marital assets pass. Marital assets are anything acquired during marriage. A good example of these are retirement accounts, investment accounts, pensions that you may have earned while married. And then any homes and or vacation homes are also marital assets. Non-marital assets are anything that has been inherited and gifts made as well, gifts received by the person, and any property owned prior to marriage is not a marital asset. Now, this gets a little confusing because if I inherit money and then I mix that with a joint account, it is then a marital asset. So inherited assets and gifting assets need to stay separate and not intertwined with other accounts. This is just a review of ownership and rights of survivorship. So joint tenancies with rights of survivorship is owning an account with somebody in equal parts, right? That person can choose to take all the money and run. You can choose to take all the money and run. So you really need to trust that person that you own assets with jointly. It's not practical for all assets. There are some, some disadvantages. It can prevent the use of some estate planning techniques. And again, just making sure that the accounts are registered in the correct way to accomplish your estate planning goals is critical in having a viable estate plan. Tenants in common is a way to register ownership of things. A typical situation there was that if I own property with two other people, we can break it into percentages, and then when I pass away, my piece, my portion has to go through probate. So anything titled tenants in common does not avoid probate, and if your goal and objective is to avoid probate, then you really need to look at how things are titled and why they're titled that way. Community property is, again, here in Texas, we're a community property state, so most everything is titled that way. And it can help with a lot of estate planning strategies and different techniques, and that, again, too, does not avoid probate at the same time. A question I get all the time is, Ransom, do I need a trust? Well, in some cases, yes, and in some cases, no. It really just depends on the individual situation and what their objectives are. But a testamentary trust is one that's created when you pass away. It's created by language in your will. So it doesn't exist while you're alive. It's only created after you pass. It names a trustee in accordance to the trust language. It helps protect the interest of minor children. It takes a little bit of time and expense to set up. But again, when somebody passes away, you're going to spend money on estate documents prior to that or after that. It's kind of an unavoidable expense. And it also has the potential to minimize estate taxes as well, which is a great thing. So going back to beneficiary designation, so assets can pass outside of probate, like I mentioned, life insurance proceeds, pensions, IRAs, deferred compensation accounts are also in there. Again, just make sure the designations are up to date. It's always important to name a secondary or a contingent beneficiary in case something happens to the primary beneficiary. And this is something I think everybody needs to know. Don't name minor children as a beneficiary. They're not of age of majority. They can't engage in contracts. They can't, essentially manage and possess their own money. So just make sure that there's, a financial guardian named as well in your estate documents. And I'll tell you something that my family did. When you're picking someone to finish raising your children, you don't want to upset any other family members. So what we did is we named one side of the family to be the physical guardian of the boys if something happens to my wife and I, and then we named a person on the other side of the family to be the financial guardian, and then they have to work, in conjunction with each other, and so that kind of appeased everyone and made it a better situation. So challenges, right? There's going to be all kinds of challenging things when we're planning for an estate. This is something I recommend everyone has. It's a letter of instruction. It's not a legal document, but it's a document that can accompany your will and accompany your trust. And basically, it just lists the locations of your documents, kind of give a good summary of your assets and liabilities and just account inventory of what you have. This is really important too. Online access, right? Write down your passwords so that people can access the things that you do and then figure out where everything is. Also list all your financial professionals, right? Your wealth manager, your CPA, any attorneys that you've worked with, make sure their business cards and their names are listed in this letter as well. Any burial wishes and personal wishes are really important too. I've seen clients even put down, like the songs that they want played at their funeral, how they want those proceedings to go. I even had one gentleman request bagpipes be at his funeral, which I thought was pretty unique. So, just anything you want to put in there, you really can. Just instructions to leave the family. You don't want them guessing and trying to figure out what to do in a very stressful time. And then also, right, let family members know where to find it, and try to keep it in a fireproof safe or a nice clean place. Even storing it digitally is not a bad idea on a thumb drive, and that way it's not susceptible to deterioration, fire, water, things of that nature. A living trust is a trust that's created during your lifetime. It is revocable, meaning that you can change it at any time because you created it, you are the trustee. Once you pass away, though, it cannot be changed and then becomes irrevocable, which means not change or no change. It's you were the trustee, right? So you're in complete charge until you pass. You'll need to name a successor trustee to take your place once you have passed away. And some trusts live on in perpetuity to benefit the next generation of kids, and then the next generation after that. Some trusts are meant to be dissolved and all assets paid out at some point, based on age qualifiers of the children or the grandchildren, whatever the case may be. Nobody gets money until they're 40, they're grown and they're supporting themselves, right? You don't want to give an 18-year-old any money from a trust. It'll probably be a fun weekend and that money will be gone. I also recommend that in your estate documents you get a pour-over will, and a pour-over will is exactly just like it sounds. It captures any assets that you forgot to put in the trust and pours them over into your existing trust at that time. Again, I mentioned at the end, the trust must be funded, and I've seen this scenario multiple times where the estate planning attorney hands you a document that's 100 pages long and it's in a nice binder. Thanks you for your time and business, pats you on the back and says, oh, by the way, don't forget to fund your trust. Well, you get to the car and you think, well, what did he mean by fund the trust? Well, you have to title your accounts into the name of the trust or it's completely worthless. So make sure that things are titled correctly. I can't tell you and emphasize how important that really is. Additional benefits of a living trust is that the family is in control in the event of an incapacity or a death. Now, this is very different because if I pass away, immediately upon passing, all of my assets are frozen, right? And I mentioned earlier about the executor getting a letter of testamentary. That may take 2 or 3 months. It may take 6 to 8 months to get that letter issued. Nobody can act on my behalf or in my accounts without that letter. So if we have a huge market downturn or something happens or the family needs money to pay bills, whatever the case may be, no one can access my stuff unless it's in a trust. The trust continues to operate after death. And so the trustee then takes over and can manage the accounts and look at them, distribute them, take care of family needs, do whatever is needed by the family. So that's a very easy way to avoid things being locked up and inaccessible. Again, privacy. So here in Texas, the county that I live in became a paperless county about 6 years ago. And so when you file your will, you go down to the courthouse, you file it, they scan it into the city computer. And what is the city computer? It's paid for by taxpayers, so it's of public record, and anybody can access it and see what my will says. I don't like that idea where a trust is settled behind closed doors with an attorney. Still have to have an attorney do some things, check some boxes, cross T's, dot I's, things of that nature. But it's in private, and so if that's important to you, privacy, and not getting involved with creditors, predators, in-laws, and outlaws, a trust is a great way to do that. So additional trust considerations, right? Depending on what state you're in, not all assets should be owned by the trust. Life insurance is a good example. Again, should not be owned by the trust. There is a life insurance trust that we'll talk about here in a minute that's a good idea if that shoe fits your situation. Annuities shouldn't be owned by the trust, and neither should IRAs. Again, the beneficiary designation takes care of a lot of those things. So a key point here, right, is just to make sure you're working with your financial advisor and your attorneys when creating the trust. I will tell you that, attorneys sometimes aren't very creative. They're more of document people. They're going to do the documents, and they're going to do a great job of doing that. Where the creativity comes in is with the financial advisor, knowing your situation and having a relationship with them, so that they know what your needs are and what you're trying to accomplish. And a lot of times, it's a great collaboration between the advisor and the attorney to figure out how to get you there and how to do what it is you want to do. It's a fact that we're all going to have or be a part of an incapacity at some point. For financial management provisions, joint accounts, right, or can be managed while I'm incapacitated by the joint account owner. A durable power of attorney allows somebody to act on my behalf for financial matters if I am unable to. And a living trust, again, can act on my behalf if I'm incapacitated. Healthcare provisions that we all need to know about and we all need to have. A living will just says how I want to be treated. A durable power of attorney for healthcare allows somebody else to make those decisions for me. Within a trust, you can also have provisions to kind of say what your feelings are about being hooked up to a breathing machine, life support, what your beliefs are about pain medicine, how you want to be treated if there's a chance you might get better. Provisions can be different, and you can explain all of that and have in your living will, have these things written out so that it's easy for the family to make decisions based on what your wishes actually are. Instead of two kids arguing about things, they can say, hey, look, Dad said right here on page 10 that if this is a situation, this is what he wants, and so that's what we're going to do. It just makes it a lot easier in a pretty stressful time. Everyone's favorite, tax considerations. I love taxes, but it's not everybody's forte. But I'll try to make this as fun and as entertaining as possible. So, estate planning tax limits. I mentioned earlier about portability, where if a husband doesn't use or one spouse doesn't use all of their exemption, the other person can use the rest of it. Currently, right now in 2022, that limit is $12,060,000 per person. That's quite a bit. The maximum estate tax rate is 40%. It's still a tiered rate, just like our personal income tax brackets are, but it gets to 40% a lot quicker than we do as individuals. Your lifetime gifting, of course, mirrors the estate tax exclusion of $12,060,000. And again, the gift tax maximum piece there is 40%. Now, a lot of times it's confusing, right? The annual exclusion is $16,000. So I can gift anybody I want $16,000, and I can do that to multiple people. But if I have, and I got a scenario here that I'll show you here in a minute. This is important as well. If both of us, my wife and I, are U.S. citizens, right? So I can gift an unlimited amount of things to her, and she can gift an unlimited amount of things to me. If your spouse is non-U.S. citizen or has dual citizenship, even at that point, the maximum there is $164,000, and that includes things you can transfer upon death, transfer during life. There are some provisions, and it makes a trust a really nice tool in that situation. One thing you'll notice at the bottom, you can see in 2017, the estate tax exemption was just a hair under 5.5 million. Then it jumped to 11, and it's indexed for inflation. That's why you see it go up slightly every year or so. This is one of the tools that Congress uses. It's always a chip on the table, and they're always sliding it to one side or the other. Actually, it wasn't too long ago when the estate tax piece was just $1 million, and the maximum estate tax rate was 48%. I hope we don't ever get back there, but it's staying at $12 million for any considerable period of time is very, very unlikely. Let's look at the different states, because I think this is important too. All the states in red have a state estate tax. So you could pay a federal estate tax and then pay a state estate tax as well. The states in purple have an inheritance tax, which is the same thing, just named differently. That's fine. And then there's one state that has both the state tax and inheritance tax, and they're kind of known for nickel and diming people to death. So my advice there is don't die in Maryland. Gifting. Let's get into that a little bit more, and I know I mentioned it on the previous slide. So this is the scenario I wanted to run by you, where I can gift anybody I want $16,000. So just by doing this, right, I'm able to, just two people are able to gift, about $192,000 to their family, and that's completely tax-free. The person making the gift is always the one that pays the gift tax, not the person receiving the gift. So you can see, right, parent one gives $16,000 to child one, and then gives $16,000 to both grandkids. Parent two does the exact same thing, so each person winds up with $32,000, and then child two, spouse, and then grandkid three all get $32,000. So really a great way to pass on assets. And some clients really like to gift during their lifetime to see the joy on people's faces and to see the benefit that it can bring them, and others would rather prefer to do that upon their passing. I've got one client who told me that he wants his last check he writes to bounce. Well, that's not practical, and I hope that doesn't happen to him, but it's something that we can look at and prepare for. Another tax strategy is accelerated charitable gifting. And this is pretty complicated, but it's a great way to essentially front load your charitable gifting in a couple of years and take a big deduction for it and get that benefit. But then the downside to that is that in the prior years after that, like the couple of years after that, there are no deductions and no itemized deductions. So we really have to be strategic in the way that we plan that and how we set it up. But again, there's all kinds of neat things we can do. I mentioned a donor advised fund earlier. What that does, it allows you to put money into a fund that you direct, right? You can choose what it's invested in and where that money goes. And I like the flexibility it provides, because I have a couple of organizations that I like to support on an annual basis. And then heaven forbid there's a disaster somewhere, a hurricane, whatever the case may be. I can have the choice to have money sent to that relief fund or that particular organization, Red Cross, United Way, whatever the case is. And I like the flexibility of being able to do that on the fly and not be pigeoned into just giving money to one place. And so again, a lot of flexibility there. So I mentioned earlier some kind of advanced techniques and some different things we can do. This is a grantor retained annuity trust, and this is great for somebody who still needs income but wants to get assets out of their estate for tax planning purposes and things of that nature. So what this does, it allows me to form a trust, still receive income from that trust, and then upon my passing, it goes to whatever charity or individual, as I say. If it goes to a charity, then my estate gets 100% deduction for the original amount given to the trust, and then I get the benefit from the income. Earlier, you heard me mention that things need to be titled into the name of the trust. In a revocable living trust, because you are the trust and the trust is you don't lose any control. In a irrevocable trust, you do lose control of the asset, but you can still benefit from the income. So there's a lot of misconceptions there that if something's in trust, you can't control it, you can't benefit from it. There's ways to get around that, and every situation is different. I mentioned earlier a life insurance trust. This is a great way to leave assets to family members. And a lot of times what I'll see is that if a client wants to leave behind a certain amount of money to a charity or to family, this is a great way to do that and to ensure that it happens. And then the client is able to spend their money and have fun and not worry about leaving an inheritance. So essentially, a trust owns a life insurance policy, and it's funded by gifting to the life insurance policy to pay the premiums on the life insurance policy. The trust pays the premiums. And then when you pass away, it's distributed according to the beneficiary designations that you make on that life insurance. And a lot of times when the the estate tax was $1 million, we would see people, fund the estate tax piece with the life insurance policy like this, so that when your family receives your inheritance, they don't receive a glass that's half empty, right? They receive a full glass of everything, instead of giving essentially half of it to the government. It's a really useful tool, and we see a lot of them in practice, and it's just a great way to be able to pass on a designated amount to your beneficiaries and loved ones. All right.
All right, so let's go ahead and open the floor up for some questions here. Here's the first question. Can you review again about the gift tax? You went a little fast there. I wanted to have you review that one more time. I know it's more complicated.
Yeah, absolutely. That's a great clarification. Let me go back to that, right, and just pull up my chart here. So gift tax is often confused and confusing. So you have $12 million, $12,060,000. I'm just going to say 12 million. You have 12 million for your estate. You have 12 million for your lifetime gifting, and then you have 16,000 for your annual gift tax. So I can gift more than 16,000 to anyone I want. I just have to use up part of my lifetime exemption. And so we see that a lot with property, maybe commercial property, residential rental property, where we want to remove it from the estate. And a lot of times it's a good idea to remove appreciating income producing assets out of your estate to the next generation. Let them pay the taxes on the income from it at a lower tax bracket, but then let them start to benefit from it. And now it's removed from my estate, so I don't have to count it towards my total exclusion amount. So earlier when I mentioned, family limited partnerships and family LLCs, a lot of times there'll be businesses that are family owned. The kids really don't have the money to purchase the small business from their parents. So what they'll do is they'll do an evaluation and set that up in a family limited partnership, and then you get some deductions for that value because it's being sold to family, and there's a lot more to it. And then the kids are able to afford it and participate in the business, and it makes transferring of businesses and or property really easy to the next generation. So just again, right, you can exclude $12 million on your estate tax when you pass away. You can gift up to $12 million during your lifetime, and then you can do 16,000 with no recourse, no tax or anything each year. If you do elect to make your annual gift, you have to file a Form 709 with the IRS with your tax return, along with your 1040, and it's an informational page. It just tells the IRS that, hey, I'm electing to use my annual exclusion, so that it doesn't come off my lifetime exclusion. And if you use your lifetime exclusion, you just have to inform them that you're doing that as well. So you can gift more than 16,000. But again, you want to be very strategic about it. Make sure you consult your wealth manager and your CPA, just to make sure you're not going to accidentally shoot yourself in the foot in the short term or the long term. Good question.
All right, here's another question. Can you review the donor advised fund versus a charitable remainder trust?
Yeah. So let's go back to that. So a charitable remainder trust is going to give the remainder, right, to the charity, and you can't necessarily participate in some of the income, but what happens though is that amount of money is put into the trust, and then whatever it grows to before you pass. So let's say I put in $1 million, it grows to 2 million, I then pass away. Well, my estate gets the $2 million deduction, not the $1 million, because it has grown, and the remainder is going to the trust, or to the charity. Sorry. And so these are just different tools to use. Sometimes it's a great technique. Sometimes there's other ways and situations to get around that. when we looked at kind of front loading your charitable gifting, there's extreme benefit to that during your lifetime, and then there's extreme benefit to some of the other trust planning tools out there that are a great benefit to your estate after you pass away. It really just depends on what your needs are and what you're trying to accomplish in order to see what is the best tool to use to get us there.
All right, let's go ahead and go into some more questions. This one is about handling debts in a will. You talked a lot about how inheritance is handled, how are debts handled?
Yeah, good question. So debts will have to be paid. These include any medical bills, credit cards, mortgages. The payments have to be made, but they don't have to be settled or paid off in that situation. And what will happen there, a lot of hospitals, credit card companies, even vehicle loans, things of that, they're very aware of the process. And so when somebody passes away, we have to let those financial institutions know that this person has passed. That account is then frozen, and they'll give you a period of time. Each institution is different. Some give you 90 days, some give you 6 months. Then when that letter of testamentary is issued to your executor, that executor will then be able to settle those debts, negotiate those debts, or just pay them off on behalf of the estate. There's also, a thing called IRD, which is income in respect to the decedent. Any income that was earned during that calendar year I pass away. So if I pass away in July and I'm receiving benefits, pension benefits, Social Security benefits, whatever the case may be, I still have to essentially pay tax on January to July on what has happened. And that's all done on the final 1040, your final tax return, and also a 706 form as well from the IRS. So you still have to pay income and you still have to pay debts, but those debts are, they'll work with you. I've never really seen a financial institution do anything egregious as far as debts go. They'll work with you, and then when your executor has a letter of testamentary, they can pay those off if they can. And if they can't, then they can negotiate those as well. But if you pass away and there's no money, then those debts are written off by the company, and that's their issue at that point.
All right, we have another question about the letter of instruction. Does that have to be part of the will or a trust?
No, actually it doesn't, and it's not even a legal document. It's just something to accompany your documents. And I found that I started recommending that letter of instruction, probably from the very beginning, around 15 years ago. I had a client pass away, and yeah, he and his wife had talked about, kind of what they wanted from time to time. But right, that's not a dinner table topic. It's not something pleasant to discuss. And I saw that family really struggle with how to proceed. And it even came down to, what songs to play. Do we have a big service? Do we have a small service? Do we have a party? Do we have a celebration of life? Or do we have a traditional, at that time, it was a Catholic family, so do we have a Catholic funeral? And they really struggled with decision. I saw how hard it was and how stressful and just overwhelming it was to them. So this letter of instruction just makes things easier for everybody all together. And in the world we live in today, right? 15 years ago, yeah, we had a couple of passwords, but they were usually, the mascot from Dad's high school, or the name of the first pet we had when we were kids. And things have gotten way more complicated now. So having those passwords and just having that information available is fantastic. And I've seen people that I know, especially during COVID, pass away, but their Facebook accounts are still on Facebook. I want my stuff taken down, I guess, after I'm gone. I don't really want to, exist in perpetuity on social media. It's bad enough as it is, but, just having all that stuff available is a really good idea. And I like having, song choice and kind of what your wishes are, and it just makes things easier. And again, just make sure that's accompanied with your estate planning documents and your will, just so people have those. And, I think it's a great idea to have your assets and liabilities written down. I had a situation once where this sweet lady passed away, and she was a client, and so was her son. She passed away, but she back a few years ago, the FDIC limit was $100,000, and so she would go and get a CD at a bank, and then if the bank up the road was offering a little better interest rate, she'd go get another CD, and a bank down the road was offering a better interest rate, she'd get another CD. Well, she had several dozen CDs scattered out that we didn't even know about, and we didn't even find out about till 2, 3, 4 years later after she had passed away, because we just didn't know. And so writing these things down and just making your family aware is going to make it a lot easier on them to settle the estate and to take care of the things they need to do to move on. It's a really good idea to have.
We've got another great question here. What's your opinion on appointing family as trustees versus appointing a corporate trustee without any personal ties?
Yeah, that's a good one. You know, I've seen it go both ways. I've also so just a scenario, typical family, 3 kids, parents are gone, oldest kid's appointed trustee, right? Because that's how things were done a few years ago. Well, come to find out, the other 2 siblings have a horrible relationship with him now because of that. He's viewed as the gatekeeper, and the other children don't like going to him and asking him for money. So in that situation, I like having a corporate trustee. A corporate trustee also is going to take care of a lot of things that people aren't even aware of. Essentially, there's 21 different things that a trustee has to do, boxes that have to be checked in order to be compliant and legal and operate a trust. It takes time, it takes knowledge, and the learning curve is very, very steep and happens very, very quickly. And if you don't do the right things, there may be penalties and taxes and different odds and ends that come to play. So a corporate trustee would take care of all of the accounting, all of the tax documents, and would be the contact person if a family member needed money. I typically see trusts written with ascertainable standards, including health, education, maintenance, and support. They can be written as loosely or as tightly as we want. Typically, if a family member, crashes their minivan, they can't petition the trust to buy them a Ferrari, right? So under the maintenance rules, they can buy them another minivan, the trust can, but it's not going to buy a Ferrari. So that can be written any way we want. But they would go to the corporate trustee and ask for that money and ask for that help, not the older brother or the older sister. It just creates a weird family dynamic. And then in some families where there's just one child, really doesn't make sense to have a corporate trustee. But I've seen I gave you the negative side of the 3 kids. I've also seen the positive side of that where it works just fine. So really, I think what it comes down to is your unique situation and your family dynamics, and no one knows that better than you. And we've all got that one crazy aunt, uncle, or cousin, or child, right? And so no one knows that better than you, and no one knows who the best person is to appoint. And again, I've seen people appoint their friends as trustee. Well, chances are if you've passed away, your friend's not far behind you. So you want somebody that can be around, be a good trustee, and a lot of times the corporate trustee is a good fit for that, but not always.
I just had a little question here as far as housekeeping goes. If you missed part of this recording, we will be sending out a link to the replay of this event in your email in the next day or so. So if you missed something, don't worry, there will be a replay. All right, here's another, we have time for another couple of questions, and then we do need to end here.
Okay.
What happens to retirement accounts or pensions at death? I know that's a broad question, but maybe you can address that.
Yeah, absolutely. So retirement accounts, 401ks, 403bs, there's many other ones, SEPs, Simples, they have a beneficiary designation. So as soon as I pass away, my family provides a death certificate, or that beneficiary provides a death certificate, and then they're awarded that money. There's new rules in effect for IRAs. You essentially had three choices with IRAs. You take the money and run, which 100% of that is taxable to the individual right then and there as ordinary income during that calendar year. That's probably the worst way to take it, because it leaves them with the least amount of money. Oftentimes that's the choice we see people take, because it's about immediate gratification and getting that money now, and I want it and I need it. But they've shot themselves in the foot from a tax perspective. And if they're making, let's say they're making $100,000 a year, and now they have a $500,000 IRA that's theirs, and they cash that out. Well, for that year, their taxable income $600,000, so they're going to pay, the 38, 40% in taxes. That's not the way to do it. The second way is to take that money over the individual's lifetime. That was the old rule. The new rule is that they have 10 years to take that money out. They don't have to take money each year, but by that 10th year, 100% of that IRA has to be distributed to them. And so those are the two choices we have now. I mentioned the third. It's no longer applicable. There's some ways to kind of plan for it, but it was essentially a trust that distributed income out over the lifetime, and maintained that to where it left it out of the beneficiary's hands. They still benefited from the money, but they couldn't make any choices, and that's been eliminated. But there are some ways to get close to that that I'm happy to discuss. But you mentioned pensions as well. So pensions are kind of a different animal. Lots of times when you elect your pension benefit, you have the ability or the options to take a lump sum, which is you take the money and it's yours and you can do what you want to with it. Or you can take an annuity, which is a lifetime payment. When you take the annuity, you're given the options of, I want this benefit to die when I die, right? The benefit goes away when I'm gone. That's the highest payout that you can get from the annuity. Another option is that when I pass away, I want my spouse to receive 50% or 75% of my benefit. That affects the dollar amount that you get month to month, but it leaves money behind after you're gone. And so if you make that election, let's say I want 75% of my benefit to go to my wife when I pass away, she'll receive 75% of my pension payment until she passes, and then when she passes, it's gone and it doesn't exist anymore. A lot of times, it depends on the company. I had clients 10 years ago who are still clients today that retired from the military, went to work for Delta and worked there for 10 or 12 years, and Delta's defined benefit plan, their pension plan, filed for bankruptcy. And in the U.S., there's a government entity called the Pension Benefit Guaranty Corporation. It ensures that you get 33% of your benefit if your pension plan files bankruptcy. I don't know anyone that can operate on 33% of what they were receiving. And so it was a really sad situation. So I have the ability to be able to run comparisons from a probability analysis to see what happens if my pension files bankruptcy. Am I still okay? Or would it be better for me to take the lump sum and invest that money and it's mine and not worry about pension payments? And I will tell you this, pensions are great, right, for the individual. They're terrible for companies. And we can see that throughout the U.S. Companies are eliminating pensions as fast as they can because they're not sustainable. They cost more money than they're worth, and it's a huge liability for the organizations, the companies, to have them. So they're getting rid of them. Very rarely do we see pensions anymore with people that are, in their 60s that are retiring now. We see less and less pensions all the time.
Thank you. We have time for one more question. This is a follow-up to choosing a corporate trustee. What category of people qualify as a corporate trustee? Like a bank official, or is this a specific title that someone gets from a specific company? Can you talk a little bit about where to look for a corporate trustee?
Absolutely. So I've been around for a long time, and The way I do things and the way we do things at my firm is that if we need a corporate trustee, we have vetted, I would say, at least 8 different corporate trustees. And we have them come and present to us. We talk to them. We figure out their companies. We look at their company, financials. We look at their process, their expertise, their ease of doing business with, and we've eliminated that down to 2 companies that I currently work with. I like both of them. It really just depends on the person's needs. One company's a little more hands-on, and then does a little bit of hand holding, which I like if needed. And then the other company is just straight, a yes sir type of company. They do the documents, they process the request, and they don't do anything else. So it really just depends on the need. But the 2 companies I work with are great, and they have done a fantastic job. And I'm pretty hard to please when I refer a client to someone. It's got to be the best of the best, because I'm putting my clients in front of those people. And like, again, I mentioned, I'm very, very hard to please, and I am very pleased with both of those companies. And yes, a bank can do it, but what I've found often, though, is that banks are going to charge a whole lot more than the trust companies. And the 2 companies I work with, you can custom tailor things, right? You can get the deluxe model where it's really fancy and everything's amazing, or you can get the basic stripped down model to get you from A to B. It really just depends on what your needs are, and what the situation is. But yeah, just know that we've done the research and we've eliminated some companies that we didn't like, and we found 2 that I guess I've worked with these 2 for the last 5 years, and really like both of them.
So it's really about research and making sure that that's a good fit for you. Okay.
Yeah, and too, I'll mention that going to a fiduciary, right, is critically important, and I am a fiduciary, and so I'm not ever going to recommend, suggest anything or any company or any person that I personally haven't vetted out and have a relationship and experience with. I think that's really important.
Yeah, I just want to mention here that people are asking for those names of the companies. Just because we are a highly regulated industry, we cannot endorse any particular company or product, but you're welcome to schedule an appointment with us, and we can definitely match you with an advisor who could give you some more information specifically to your specific circumstance. So that's the question on that, to address that. Well, folks, we have reached the end of the time we have for this webinar. I want to thank Ransom. This has been so informative, and I want to thank our audience for such great questions. And we're looking forward to having a replay of this webinar available to you. We will also post it on our website as well. Thank you so much to the organizations that have made this webinar possible today. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Every one of our advisor partners is committed to offer a free initial consultation to anyone we match them with. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we will see you at another webinar soon. Goodbye, everyone.